Hello and welcome back to the channel. Thank you for joining me in another of my wonderful interviews. Today, we're going to be looking at property and how the government is planning and indeed doing, taking over your property and the way that they're going to, your local council, your municipality, if you like, is taking advantage of you and grabbing your property, and how perhaps we can protect ourselves. Knowledge is a good thing, and to help us through this, it's good old Stan McDonald. Hello, Stan.
Hello, Richard. It's good to be here.
It's good to have you back. I've noticed that you've been putting some of our previous presentations up on your channel, which is fantastic, so that other people can get to grips with some of the stuff that we've done. Have you had good feedback from that?
Yes, especially the question and answer period one. People said that was a really good idea.
Oh, well, we should do that again then.
Yes, and I think it would be beneficial. Now, if I don't have the answers, I can probably look them up, or at least I can guide people, even if I don't have all the answers. But I have a lot of them, because when I study something, I get into it quite deep. And one time in the previous presentation, you had asked me how I got involved in the legal stuff. And this presentation is actually basically the information I had to learn at that time. And I figured it should be shared with the general population.
Absolutely, right? and that's what we pride ourselves on doing as much as we can, within the allowance that platforms like this will let us do it, and indeed governments, without sort of demonetizing us along the way. But anyway, that's a minor point. We want to share the information. So we're talking about property, and so can you just give us an overview of what we're going to be looking at? You give me something like 47 slides to go through, but can you just tell me what it is in principle we're exploring?
Yes, in the province of Ontario, but this applies also to the UK, and in fact all of Canada, for that matter. We have provinces, which are separate corporations. We can look that up on sec.gov. The provinces are all separate for-profit corporations, just as you guys have in the UK. And what they're doing is illegal, but actually it's enslavement, and I'm going to uncover that today. Now, I'm specifically focusing on Ontario law, but that's because I can't do 12 presentations or 13 over the same thing. It's basically the same rules are going to apply everywhere.
Right. So although you're talking about Ontario, people in the in England and Wales, because UK is just a corporation and a concept rather than an actual place, they can, well, we may as well say it, people can follow and check out on legislation.co.uk to sort of see if these same rules apply.
And they do. In fact, they do. I checked it out. But you had asked me, when we first did our first interview, you asked me how did I get involved in doing this legal stuff? Yeah. And that was about 40 years ago, and I was my family was harassed by the local municipality. The corporation of the City of Belleville is how they entitled their paperwork. So that's telling you they're a corporation. And I looked at that, what? And in fact, they are a corporation, and I learned the law quite in depth after that. And in fact, the city solicitors outright told them right in court that they can't defend against my claims. Because when I understand a claim, I try to understand it backwards, forwards, upside down, and in reverse, so that there's no stone unturned. And this is the way I take on these legal things. And that's why we've done so many presentations about each specific issue with council tax, which we now are going to apply to this, because, I mean, there's all kinds of different discrepancies with council tax, and there's all kinds of discrepancies here. But the good thing with this presentation is it overlaps into the UK and every other province or territory or district, because all these municipalities or councils, boroughs, they're all for-profit corporations, and they all have, most of them, if not all of them, have a Dun and Bradstreet number. Yes. And we've covered it once before, that if they have a Dun and Bradstreet number, they're basically taking on the same role as any other corporation.
Yeah.
And so
absolutely. So, and they have that. Then they no longer have the rights that they would have had if they were not incorporated, but if they were real, genuine boroughs given a charter from, down on high, as we used to understand it.
Right. Now, one of the things that the people can do is they can actually write to their local council or borough or corporation and ask for a copy of the charter. And that's being done now in Ontario and in Canada. And we're finding out that they either don't have a charter or their charter is actually swearing allegiance to the for-profit corporation, which is now self-evident that they don't represent the people.
Yes. Well, we saw that with the new Labour government coming in, with the MPs supposedly swearing allegiance, their oath, to the Crown Corporation, not to the people who just elected them.
Exactly. And our government did the same thing. We have Trudeau, and he swore an allegiance to the Crown. Now, you got to remember there's Crown and there's Crown with an E. Now, which is which, who cares? But the point of it being that that Crown is a corporation. So they're not swearing allegiance, as you just said. They're not swearing allegiance to the people. It's a for-profit corporation. And because these are corporations, they're actually registered in Ontario or in Canada under the Business Names Act. And therefore, they are a corporation. And you guys have the same thing. You have a registration system over there, too.
Yes.
And many times we find out these corporations, some of them are defunct. Some of them haven't been listed for a while on Companies House. They're out of business, and they're still operating anyway. Well, if they're a de facto corporation operating in bankruptcy, basically they're insolvent, they have no legal authority to do anything.
Right.
Once the company's bankrupt, it's out of business. Now, if we wanted to go one further, all we got to do is look at the national debt. If all these companies, corporations, call them whatever you will, have a national debt, well, wait a minute. Then they are in bankruptcy. They're not operating in the positive. So technically, if they're bankrupt, they're out of business anyway. Yes, but rather than get into that argument, exactly. Yeah. So if we can do it now, where we can show them right in their own laws that they're, basically not operating correctly, we should be ahead of the race. Now, we all know that the corporations are for profit. That's why we have corrupt courts and corrupt judges. And not saying they're all corrupt, but there is a certain
But I mean, ultimately, they're working. I mean, even if they're not corrupt, they're still working for a fraudulent entity.
Exactly.
Because they shouldn't be.
They're aiding and abetting criminal activity. Yeah.
Right. Okay, so you've sent me a whole load of slides. We're going to go through those, and people can sit back and enjoy the experience, as I always do when you take control, and we'll enjoy the presentation as you go through it, and then I'll only stop you to ask and just to sort of clarify certain points.
Yep, that's fine.
Great. So let me just switch to our slides. So here we go. Property rights in Ontario, and brackets over in Britain as well, and other Commonwealth countries that follow the same sort of legal system.
Exactly. Yep.
Right. What you need to know when they come for you. Over to you,
and
Stan.
They are. Many corporations are now trying to take over land and redevelop it and put in solar panels or whatever under the guise of clean up the environment. And if they were really truly interested about cleaning up the environment, they wouldn't be doing their geoengineering project. Just leave it at that. So if we go to the next slide, Richard, it's basically I'm going to shoot them right out of the water on the second slide, basically.
Right.
Could you bring that up for me?
Yep.
Okay, under the Municipal Act 2001, I'm just showing you where we're getting this information from, because this is specifically tailored to Ontario, but as we said earlier, it applies to everywhere.
Yeah.
So if we go to the next slide, if we look under Section 4, it says body corporate. The inhabitants of every municipality are incorporated as a body corporate. Now, I've checked every separate province, and they're all the same thing. In fact, the City of Toronto Act is another one, and it says the same thing. So that's telling you now that the municipality is basically, because you're the inhabitant of every municipality, is incorporated as a body corporate. So that makes you a corporate employee. But you're a corporate employee without pay. So would you go to work for a company that you never got paid? No. Right? But the guy comes knocking on your door and says, if you don't pay us under our corporate policy, then we're going to clamp your car. We're going to do a committal to prison. We're going to do whatever. So they're in essence making you a slave.
Yes.
Right? That's in essence what it is. But now that we know that we're a body corporate, if we wanted to have some fun with these people, we could send them a bill. And when they don't pay the bill, which is what we want them to not do, we don't want them to pay the bill, then we can say, okay, well, then you have no equitable claim, because you, as the inhabitant, as the person occupying your dwelling, your home, you do labor. You mow your lawn, you paint the house, you fix the thing up, you maintain it, whatever. So therefore, you have an equitable claim because it costs you money to do that.
Yes.
The municipality, on the other hand, has no equitable claim. And when you point out a problem, like let's say your house wasn't built properly, and you bring them this information, you ask them for a copy of the building permit or the whatever occupancy permit or the inspections, they won't provide them. Because if they did provide them and you can point out where these discrepancies are, then in fact, you could go after the municipality. But the very fact that they're taxing your property and it should conform to a certain building code, a certain building regulation, and it doesn't, means that they're derelict in their duty and your property is actually non-taxable.
Right.
So,
yeah.
Because if it doesn't conform, you bought it in good faith that it was basically conforming to the building code. And in fact, in the case of my property, it wasn't.
Right.
So,
next slide.
So far?
No questions at all. Absolutely.
Okay, so many municipalities, how they're trying to entrap people, they're creating a clean yards or some other similar bylaw in order to clamp down on the homeowner. Okay, and some of them are even stating that they have unplated or expired stickers on vehicles on their property, and that's not permitted. Well, I have a letter from the Ministry of Transport that says vehicles on private property, at least in Ontario, do not require license plates, insurance, or registration. And this was forwarded to the local municipality prior to a court case, and they proceeded anyway because the courts are corrupt. And I was given to Samantha Short, which was the bylaw enforcement officer, and also to Brett Forrestal, and they continued on anyway, and they had an illegal fraudulent court case that cost me $15,000. Because the courts, in fact, are corrupt, and I'm bringing it forward. So my bad experience may give you some evidence that you can use against these corrupt corporations. Now, the fact that the court operated outside its legal framework means it's ultra virus. It has no authority to do so. And you have the same problem with your council tax in England.
Yes.
Right? They're operating totally outside their legal framework. And we've done a number of presentations, and there's a number on my YouTube channel that go over specific issues. And I've also, just in case something happens to Richard's show, downloaded the presentations that I've done with them, so you can find them there as well. But in fact, the municipality does not have the right to regulate the licensing and parking of motor vehicles, as we'll get into later.
Okay.
So if we get into the next slide, Richard. Now, what these municipalities are doing, and they're also naming this on people's houses, is they're saying they're derelict. So I went and looked up the word derelict. Now, if a vehicle has all of its parts, or at least appears to have all of its parts, i.e. doors, fenders, hood, and that type of thing, then it can't fit the definition of derelict, which in this case means run down. Okay, lacking a sense of duty, which is neglected. Well, the municipality is neglecting all the time to read their own laws. And then on the other side, it says forsaken or abandoned. Well, if your vehicle is on your property or your boat, because now the municipalities are trying to clamp down on people having a recreational craft or boats or trailers in their yard, well, again, that falls under the Highway Traffic Act under Section 7, so they have no right to do this. And I told the municipality this in a public meeting, and there were other people there that stated the same thing in the City of Belleville, Corporation of the City of Belleville. And they said they were going to pass the bylaw anyway. Well, because they passed the bylaw anyway, you have a right under Section 273 of the Municipal Act to charge the municipality because they're breaking the law. So you have a right to appeal that. And the same thing happens when you guys go into your council tax in the UK. Now, in the UK, there's two avenues. You can do a judicial review, which is saying, your laws are unconstitutional or to the detriment of the people, or you can file an appeal. But the only time you can file an appeal in a court case is if the court made an error in law. Well, in our case, we have the right to challenge the validity of the bylaw, which in effect is sort of like a judicial review. So if we go to the next slide, we'll carry on with some of this. Okay, the municipality doesn't have the right to regulate the licensing and parking of motor vehicles in Ontario, pursuant to Section 50 of the Municipal Act, which clearly states here that the Municipal Act states the municipality does not have the power to pass a bylaw establishing a system of permit for motor vehicles or trailers, those terms are defined under the Highway Traffic Act. It's actually under Section 7. So that answers the question of can they regulate vehicles on your private property? The answer is no. Right. But that goes for trailers, because trailers are classified as a vehicle when they're being towed down the road.
Oh, are they? That's interesting.
And the same thing with a boat, because a boat is a watercraft, but it's still a vehicle. That's why you need a license to operate it, theoretically. Right. So that answers that. Now, the municipality doesn't have the right to regulate the parking of that motor vehicle either, pursuant to Section 63(1) of the Municipal Act. The license plating of vehicles falls under the Highway Traffic Act again, which is again under Section 7.1. So now that if anybody's been hassled or told to dispose of vehicles on private property in the province of Ontario, provided the vehicle wasn't meeting the definition of derelict, you have a recourse.
And just as a matter of interest there, you've got a vehicle on your property. I mean, obviously this isn't counting those ones that are parked on the road outside your house. But if this is on your driveway, your own private driveway, I mean, it shouldn't have anything whatsoever at all to do with anyone else, whether it's falling to bits. I mean, it might be a piece of art when it's falling to bits, and they can hardly say it's abandoned if it's on your property, because you may be using it for spares and parts.
Yeah, the municipality doesn't want you to fix your own vehicle, so I would send them an invoice and say, are you prepared to cover this? And of course, their answer is going to be screw off, not going to do that. So then you say, well, then I got to do what I got to do, right?
Yeah.
So we're done with that slide.
Okay, hang on, I've got to find the next one.
Now, the impounding of objects on motor vehicles, and this is exactly what you just mentioned. Right. If the municipality passes a bylaw prohibiting or regulating the placing, stopping, standing, or parking of an object or vehicle on or near a highway, it may provide for the removal and impounding or restricting and immobilizing any such object or vehicle placed, stopped, standing, or parked on or near a highway in contravention of the bylaw. And that's subsection 170.15 of the Highway Traffic Act. So again, if you park your vehicle, on the highway or near the edge of the road, yes, they can remove it, because the roads have to be clear for other people to park their cars when they break down. And also in the wintertime, we have snowplows that go through, and if your car's there, it probably won't fare too well.
Yeah. Okay. We don't have many snowplows in England.
No, thankfully. And subsection 1 does not authorize any action with respect to a motor vehicle on a parking lot or land not owned or occupied by the municipality. So I don't know how much clearer that can get, right? So they don't have the right to regulate the licensing and parking of motor vehicles. So when the court did this to me, even though it was illegal, and I proved that the vehicles were in good shape and there was nothing missing, the two judges actually, had two cases, operated illegally. So now that court has no authority. And what I don't know how you want to run this, but people have come on your show that have been railroaded by the system in one form or another.
Yes.
And maybe what we need to do is start exposing the fraud. Instead of saying, here's your solution, keep exposing the fraud. Now, in one of our interviews previously, I had asked your viewers to send me an email if they've ever been screwed over by the local council tax. And I need a copy of the liability order.
Yes.
If they would send that to me, we would be able to start building a case against these municipalities.
But they don't have a genuine liability order. That's the thing. It's never produced.
That's what we want. We want the fraudulent liability order.
Right.
Because when they send you some BS garbage, that now becomes mail fraud. That now becomes a criminal offense. And because these people are supposedly officers of the court, especially in the UK, there's a lot more severe penalty because they in fact are officers of the court. This is the only way we're going to turn this thing around. Everybody can look at... Go ahead.
No, sorry, I was just going to say, in the UK, in England, I must stop using UK because that is just a business thing. In England, they'll send you... The council are the ones that send you what they claim to be the liability order, but it's a council one with a fake crown copy on it, pretending it's come from the court. It's not come from the court because the courts do not issue a liability order for council tax. They have been told by the justice system they can't do it. It's a hearing, and if you're not there to hear it, that's it. It's not written down.
Exactly. So we can use all this against them.
Yeah, exactly.
Yeah. So this is why I wanted these fraudulent liability orders sent over, and then I could deal with that.
Right.
But right now I only have 2.
Oh, okay. We'll see if we can get some more from people. If people want to send in a copy of the fake liability order, obviously take a photograph of it or scan it or something. Do you want me to put your email address in the thing so people can send them directly to you? So it saves coming through me and getting lost in my email box.
Right. Grand. Yeah, I'll give them until the end of July to deal with this.
Right.
So if you have one of these things, send it over, because what I want to do is compile the evidence so other people can use that fake liability order to prove that this isn't an isolated incident.
Yes.
But
okay, so we're on to the next slide now.
Yeah, the municipality has bothered. Okay, if the municipality has bothered you over 1 year ago on a similar issue, nothing was done about it, then you're protected under Section 36 sub 8 of the Building Code Act under the limitations period. And it says here, no proceeding under this section shall be commenced more than 1 year after the facts on which the proceeding is based first came to the knowledge of an officer, which would probably be a bylaw officer, where the proceeding in respect to enforcement of the bylaw passed under Section 15.1 or the chief building official in any other case. So that might be a previous employee.
So is that is that down to also on the UK's legislation.co.uk site, or is
no,
not
in your case. No, you guys would have to look under the actual Limitation Act because you don't have a specific building code the same way this one's written out.
Right. Okay, so there's a little bit of homework for people there.
Yeah, but the same thing would apply. You still have a statute of limitations.
Right.
Now, clearly, violating what they do is they're violating the International Covenant on Civil and Political Rights. And that international, obviously, is global. And under Section 26 of the Charter of Rights and Freedoms, which reads as follows. Article 17, no one shall be subject to arbitrary or unlawful interference with his private family, home, or correspondence, nor to the unlawful attacks on his honor and reputation. Everyone has the right to be protected under law against such infringements and attacks. So therefore, you can use that international covenant law in the UK because it's international, right?
Right.
And so when they try to take your vehicle and they want to trespass inside your home, which they have no right to do, that's invading your privacy, your family, your home, and in some cases they even tell you that the municipality moved or they don't deliver the letters. So that's interfering with your correspondence. And also when you try to file paperwork in your courts, you're told to send them back to the municipality or council, which is another interference. So now you've got international law that helps both Canadian people getting railroaded under this property standard stuff, but it also helps you guys because the municipality and the unlawful courts are aiding and abetting one another, along with the private bailiff, to interfere on your rights.
Mm. Okay.
That solves that problem. Now, if the municipality thinks its bylaw has superiority over the statute, it's sadly mistaken. Section 14 of the Municipal Act clearly states that if we have a conflict between the bylaw and the statute would obviously take precedence.
Yes.
And that's because it's a pyramid system, right? The municipality is the lowest form of government. Then we have the provincial government on top of that. And then we have the federal government. And then we have international law on top of that. So this is where we're going to start to maybe get a remedy. If people stick together, and that's the biggest problem. We can't get anybody to stick together.
No, that does seem to be the biggest problem at the moment.
Yeah, you guys in the UK are way better than us in Canada, I'll tell you that.
Ah, right. Oh, that's encouraging.
Yeah. If the municipality would claim it has jurisdiction under 15.2 of the Building Code, which only is a half-truth, Section 15 of the Building Code is restricted under various statutes, one being the Municipal Act and under Sections 9, 10, and 11. And they're limited to what they can do based on those provisions. In fact, there are 74 statutes that I'm aware of that regulate the municipality and its authority. Now, one slide I didn't put in here is the chief building official under the building code only has the right and regulation over sewers and plumbing. So therefore, how can the bylaw enforcement lady or man have the right to do more than their boss has? If their boss can only regulate sewers and plumbing, then the municipality can't regulate any more than sewers and plumbing through its bylaw. So you have to check the scope of the authority of the individual. Now, you guys in the UK have the same problem when they send a bailiff. They also bring the police force, but the police only have jurisdiction over civil matters, over criminal matters.
Yes.
No jurisdiction over civil matters, and we have the same issue here in Canada. So when they brought the police to my door, I said, you guys have no authority here. Go away.
Yes. And
we're here to back up the town. We're here to back up the municipality or the council. And the answer is, well, what jurisdiction do you have in a civil matter? Well, generally none. I said, then you're only here to maintain the peace.
Exactly, and that's what people in this country are saying to the police, that they're here to keep the peace, and so they should really be standing back and just observing. And if everyone's acting honourably and calmly, there is no reason for the police to get involved. Although recently, when Julia had an issue, and it was our ex actually in the end that had the problem, but we didn't realise it initially, the police were coming in saying, no, we're here to mediate. Excuse me? What your role is not to mediate. The business is between the bailiff and Julia's ex. Thank you very much. We're not going to get into a fight. They're going to negotiate whatever they need to negotiate and question whatever they need to question. If the paperwork isn't accurate, then there's no business here. Thank you very much. And the police can just stand back, but they didn't, and they refused to stand back.
Well, in fact, the contractor, the issue is not even with the private bailiff, because in that case, that debt was already written off or sold or whatever, and there was no deed of assignment, so therefore the bailiff had no right to try and collect on it.
Yes,
exactly. And one of the other
Mm-hmm.
issues that they try and pull is they say we have a warrant of entry or a warrant of control. Now, in the UK, a warrant of entry is only applicable in a criminal situation. So if you were having stolen property or you were harboring a fugitive from law, they might have the right to go in there and collect the individual or the evidence. And a warrant of control is only usable if you were, say, selling a product from some company and you had a bunch of their product and weren't paying the bill. Then they could go back and say, well, we're here to collect the goods that you haven't sold to recover part of the debt. So, in fact, they have no right of entry to your property whatsoever.
Yes.
Yep.
Okay, so so that we can see how that that law is affected on both sides. So here's the next slide.
Yep, Section 9 says the municipality has the rights and duties of a natural person. Now, if we went back to our second slide in this presentation, if you remember, it said the people of the inhabitants are body corporate. Well, the same thing's happening to you guys in the UK, and here what they're doing is they're converting the corporate to a natural person, because one corporation can't really technically take an individual to court. So what they're doing is, next slide, Richard.
Oh, it was the next one. Sorry, I was just going back to, that one.
I didn't know you could do that. Okay, so the body corporate, the inhabitants of every municipality are a body corporate. So they're making you out to be a corporate employee. Now, if we go back to the other slide that we were just at, the blue one.
Yeah, now I've just got to remember what number we were at.
I didn't number them, unfortunately. I can't.
No, they are numbered, but here we go.
Yeah, here we go. So now what they're doing here, it says, states the municipality has the rights and duties of a natural person. So what they're doing is they're converting the corporation into an individual, a human being.
Have you frozen there for a little bit?
Yeah. Okay, one person, you can't enslave another person without a contract, right? I can't bind you to any sort of contract without your authorization, without a signature.
Yeah.
So this is what the municipalities are doing. But this is good because in this case, if they're going to assume the position of a natural person, then I have the right to go after that fictitious corporation because they have the rights of a natural person.
Is that happening in the UK, in England and Wales? Is that they're doing that in ours?
Yeah, same thing. Same thing.
Right.
So you can see how these laws, even though I'm using Ontario, I'm going to now apply it to the UK, and that's why I cover part of the UK and then back to Ontario. But this applies everywhere. We could go through France, Germany, all of these, 200 and some odd countries, same thing.
Yes, yes.
So if we go to the next slide, we're going to even get some more information. 10 and 11 regulate what the municipality has the authority to do. It comes down to the fact they have the authority over public property and economic development, signs and sewage, and drainage. They have no authority over private property, none whatsoever.
Right. And so that should be bloody obvious, shouldn't it? That they over public property, but not private property. Private property is private, so bog off.
Right, exactly. And we get into some more of this a little bit further down, but it said now to even fix this further, there's Regulation 322/12, which is an extension of the Municipal Act, which specifically states that the municipality has no authority on private property. It says here, Regulation 322/12, under the Municipal Act, scope of local improvement. Nothing in this regulation authorizes the municipality to enter and undertake work on a local improvement on private property without the permission of the owner.
Right.
Or other person having authority. So they can't come on your property and steal your property. In fact, if they do, you have legal recourse in Canada under the criminal code. It's called the Trespass to Property Act. And you have the right to use reasonable force to get these people off your property or to get back the property they've stolen from you. Just so you're aware.
Yeah.
The first thing every property owner needs to do is place a gate. And this applies in the UK, Canada, globally, this applies. You place a gate on the normal entrance of your property, usually a driveway or a laneway. It could be a chain going across it saying private property. I don't care. In my opinion, the gate should be solid so they can't see through it. This will eliminate the municipality from stating they got some sort of BS complaint, which they never have produced in 40 years, from somebody driving by, which is what they last claimed. And then I caught them run their own paperwork because they issued it on their own letterhead, which means they wrote their own complaint, which they admitted in a court of law. And yet the judge allowed it to go through. So the judge now has a bigger problem. Okay, the gate should have a clear sign on it posting private property.
And some properties in the UK, they don't have a gate. Some of the doors just go straight onto the pavement. So, the door is the gate. So I guess you should be having on that front door your private property, no That's implied rights of trespass and trespass and all of that.
Right. Now, if you wanted to do it, Richard, if you knew a sign printing place, you could make up a sign like that and sell it off your channel for those that don't know how to do it or can't get it done.
Yeah, that's true. Well, now they've been demonetized, it's like, might need to set up a business doing that sort of thing.
Something. Yeah.
Yeah. Okay. Let's get to the next.
Okay, we're done.
Okay.
And there's a picture of a gate and it's marked private property. Now, how can anybody see anything there? Right? If you're passing by, you're not going to look through that little gap.
Right.
Right? It just gets the point across. That picture's distorted to fit the screen. But anyway, you get the idea.
Yeah.
Okay? The second thing every property owner needs to do is place the municipality on notice that your property is, in fact, private property. Now, what I'm telling you here falls under the Trespass to Property Act. So to do this, you send them a registered letter to the clerk's office for your municipality indicating you want it addressed at the next council meeting and put it on the council record, which you're obligated to do. Send a duplicate letter to the chief of police so that they know, so when the local thugs municipality tries to enlist their help, they already know it's private property. Or to the OPP, if you don't have the local municipality, a lot of provinces or territories don't have local police force, they enlist the services of the OPP or the RCMP.
Right.
And also send a copy to the chief building official of the town so they can't send their bylaw enforcement officers stating they have such authority because you've removed that right. If they won't accept your registered letter, which is common over here, send them a fax, send it by courier, or hand deliver it, or do all three.
Right. So that's really interesting. I mean, over here, so we would send that to the councils. Yep. You would go to the council with a letter and saying, I am making you aware that this property is private and that you have no jurisdiction whatsoever over it. Thank you very much. It can be a polite letter. It's a notice, isn't it? Is it effectively a notice rather than a letter?
Yes, because letters can be ignored. Yeah. But if you could put in that notice that there's no implied right of access and any implied right is hereby been removed, and put a date on it and sign it.
Yes.
Right? Because now you're putting authority. When you sign a document, you put authority to it.
Right. Absolutely. Brilliant.
And you can even you can put on it all rights reserved because you're reserving your rights. I would not put without prejudice on it because I want that thing. And that we without prejudice means that whatever we do is not going to be used against us in court. So many people put without prejudice on a document, but I want this thing prejudiced because I want to be able to use it in court.
Right, because it's part of any defense that you might need to have.
Right. So never sign a document you intend to use in court on a without prejudice basis.
Right. Okay.
Many people are making that mistake. Okay, next slide.
Yeah, bear with me. I've got to get to here it is.
You got too many buttons there, Richard. Okay, what to do if you are being harassed? Take photos and do an inventory of everything on your property, including but not limited to vehicles, boats, materials, building and construction equipment, or other materials. Make a list with the serial numbers and model numbers and the replacement cost. Put this in an affidavit format, because if you have photographs to prove that it was on your property and they steal it, which is technically theft or armed theft, then you can prove it and you can put a claim in for replacement value and sue the municipality. And by the way, if they do take your property, they have to give you a receipt. And that applies to you guys in the UK as well.
That's really interesting because I read a book by Paul Yates, I think it is, the book's called The Title's Not Important. And
yes,
he tells
I have that book here.
Right. He tells the story of somebody with the bailiffs turn up. The guy didn't realise who they were, opened the door, they were already in. They started to take some of his furniture and various bits of property, and they were loading it onto the van. And then the author turns up and says, "What's going on here?" And he says, "Oh, the bailiffs have come, they've got their rights to do this and they've got the paperwork." And he said, "Right, okay, well, they're going to have to get you to sign for the stuff." And he said, "Don't sign." So when it came, they loaded up the van, apparently, and then the guy comes in and says, "Right, okay, here, mate, just sign here to say that we've got your property, blah, blah." And he said, "No, I'm not going to." "Oh, you have to."
That's right.
He says, "No, I don't." And he didn't sign. And so in the end, the bailiff bloke said, "Oh, bugger. All right, lads, unload it." And they had to bring it all back in.
Right, because if he signed it, then he's agreeing.
Yes. Now, there was a case, I interviewed a lady called Lucy on the show about 3-4 months ago. She had her car taken by bailiff. She was actually physically pulled out of the car. She was sitting in the car by the police. The police pulled her out. The bailiffs loaded it onto a lorry and towed it away. And I asked her specifically, because I'd read that thing in the book, I said, "Did you sign for it? Did they make you sign?" She said, "I signed nothing." So to me, then it was just stolen.
That's right.
But they, because she didn't, I suppose she didn't say, "Hang on a second, I have not signed, you have not agreed to anything, you can't do this." Although she was stating that all the way through, I don't consent to this, you have no right, blah, blah, blah. But they did it anyway.
Does she have a recording of it?
Yeah.
Good. We can use that against them.
But that's very interesting.
Right. So this one's done now. Now, inspection of property without a warrant. Where a bylaw under section 15.1 is in effect, an officer may, upon producing proper identification, enter upon to a property at a reasonable time without a warrant for the purpose of inspecting the property. Because, see, what they do is illegal because they are already convicting you before you've even had a trial. And this is evidence of it right here. But remember that there's section 15.2 of the building code is restricted by sections 9, 10, and 11. And what did 9, 10, and 11 tell you? Natural person and only public property, public assets. So in actual fact, the bylaw under section 15.1 doesn't apply to you. So therefore they have no right because it's limited by sections 9, 10, and 11.
And you don't have to let people in. I mean, you don't have to let people in anyway to your house, do you? I mean, unless they've got actual paperwork from a criminal court.
Right.
You haven't got to let them in. What about rented property? If you're rented and they're coming in to take your property and you rent the property, it's still private property. It's just you happen to be renting it from somebody else. If you rent it from the council, is that a different situation?
Well, it is a little bit because the property belongs to the council, but the people that are trespassing on your property now are in fact bailiffs. And in fact, what you want to do if you're getting harassed by these monkeys is verify that they're a certified bailiff. When I dealt with the council tax about a year and a half, 2 years ago now, it worked out that the council had hired a bailiff, Duke's bailiff, and at that time, Duke's bailiff wasn't a registered proper bailiff.
Right.
And when I found this information out, I informed them. So then I got a copy of the registration that I dug up. And it was registered sometime in the future. So that in fact, they were not authorized to be operating as registered bailiffs when in fact they were doing what they were doing.
Yes.
So they will pull all kinds of shenanigans. And it's approved, in your case, it's approved by a court.
Yes.
Right? So the court is actually now aiding and abetting an accomplice in a criminal activity because they're not in fact registered.
Right.
Yep.
Okay.
So remember, this bylaw under section 15.1 is contingent upon the broad authority. Okay, and the broad authority is under 9, 10, and 11, and we'll get into a little bit more than that. But remember this, that they don't have the right to enter onto even your land, okay? Because your property is not only your house, it's also your land, and many times they'll trespass on your property without you even knowing about it.
And
which
that's
is what
why having
Samantha
a gate.
Short did. That's why you have the gate. Now, in my case, Samantha Short and her partner in crime, Brittany Moray, circumvented the gate. So they're actually in criminal breach of public trust and section 121 of the Criminal Code of Canada. But the courts didn't care. This is to show how corrupt the court systems are.
Right.
So you guys have the same problem. Now, the contents of the order, an officer who finds the property doesn't conform with the order, and provided they have the authority to do so, okay, has to give you the municipal address and a description of the property. Now, notice it says municipal address. That's a trick word now, isn't it? Because the municipal address wouldn't be your address because your property is private, right? And they're supposed to give out reasonable particulars of the repairs to be made, or stating the site has to be cleared of all buildings and structures if, in fact, they presented a health or safety risk. They don't tell you that, okay? But anything other than that, they have no right to enter your property whatsoever. Job done. Now, conflict between a bylaw and a statute, okay? A bylaw is without force and effect to the extent of conflict with a provincial or federal, and I would also say international, act or regulation made under such act, or an instrument of legislative nature. Now, an instrument in this case happens to be any law I can find, because they're an instrument of law, including an order, license, approval made, issued under provincial or federal act or regulation. So this is where under the Highway Traffic Act, right, which is a provincial legislation, provincial law, okay, they don't have the right to regulate the licensing and parking of motor vehicles because it falls under Section 7 of the Highway Traffic Act. So now anybody that's been screwed over by the local municipality has a recourse now to go after these people. And notice I said people because somebody had to sign the document. You can go to the next one. Somebody had to sign the document, so therefore they become the liable party.
But they don't. I mean, this is the other thing that we're finding now, that these corporations, they'll send out the letters. They're not signed. And sometimes the letters would just be, from the so-and-so officer. And it's like, well, who's that? Is that little noddy in the corner? What role does that do? They're hiding behind the protection of the corporation, and they're not actually signed by any living man or woman.
Right. Now, in your case in the UK, or we'll call it UK, you have a section 151 officer within each council or borough, and that's the compliance officer. So go find out who that person is. Okay, the section 151 officer, if you find out them, you can say, look, this is the problem, outline the problem, address it directly to them as a notice, not a letter, and then hold them accountable.
So the section 151 officer is the compliant officer of every council?
Yes, And then in the case of a council tax issue, okay, there's a legal advisor. And the legal advisor, when you go into a court hearing, we'll call it court even though we know it's not,
yeah,
they're supposed to tell the magistrate anything that can be used for your case, which help you, as well as anything they can use in their favor to help their case.
right.
And they're supposed to divulge both sides of that equation, whether it's detrimental to their case or not, whether it's detrimental to your case or not, and they don't do that. So the compliance officer and now the legal advisor in the case of Lancaster City Council and their magistrate court, it's a guy named Iman Gorgi. Okay,
so instead of calling them a compliant officer, it sounds like they're much more likely to be known as the biased officer, because they're biased in favour of the council, because they don't seem to be helping or assisting the individual who the council are after. Right.
And in fact, we have a document now that proves that when the courts are enlisted their services, they're not supposed to give the illusion that the council's in charge. Because the council rents the room from the court.
Yes.
So, I mean, that's total conflict of interest.
Absolutely. I mean, it becomes a kangaroo court.
The same thing happens in Ontario here. If you get bothered by the bylaw enforcement officer, you can appeal it to the local council. Well, the local council has the duty under their own laws to uphold the things to whatever the city bylaw person put through. So obviously, you're not going to get a fair trial when you go to do an appeals hearing. And then if you go to the appeals to a court, the court has the same authority as the appeals committee. So again, it's a rigged system and it's against you.
Yes. It's terrible.
Yeah, you guys have the same problem. Okay, next slide. Now, without restricting the generality of subsection 1, there is a conflict between the bylaw of a municipality and an act or regulation or instrument described in that subsection. If the bylaw frustrates the purpose of the act or regulation or instrument, it's of no force and effect. Okay? So that tells you that the bylaw can't supersede higher laws.
Yeah.
Simple enough, right?
Yeah.
Next slide. Now, what to do if you're being harassed. The municipality or anyone acting on behalf of the municipality does not have the legal right to enter your living space, i.e. your home. In fact, they can't enter any building, whether it's a home or a garage or what it is. If you're also protected under the Trespass to Property Act, you guys have a similar one in the UK, and can use as much force as is needed reasonably to remove the trespasser if they won't leave upon your request. You get this authority under Section 35 of the Criminal Code of Canada. If they attempt to enter or have entered, you can ask them for a copy of the warrant or the order. If they don't have it, you can refuse them entry and tell them to get lost, basically. So now you can see I mentioned the Criminal Code of Canada. So now what they're doing is a criminal offense. So now you can have them charged criminally. And the courts will have you believe, at least in Canada, and I did check this across all of Canada, that you can't lay a criminal prosecution in Canada for the wrongdoing of an individual, a public official. Well, I'm here to tell you that, in fact, you can. Okay, that's not the purpose of this presentation, but to let you know that, yes, it is, in fact, possible. And you guys can do the same thing in the UK. Next slide. If the municipality is claiming some violation of some bylaw, get a copy of the bylaw and just look and see on what date it was signed. All too often, the bylaws pass first, second, and third reading all on the same day, which is not permitted, or they're not signed at all, which means they're not legal. Any document that's not signed is not executed. That's why I tell everybody, sign your documents, scan them in once you've done so, and then you have a signed copy that you can reuse in court as evidence. Read the bylaw, because often times the bylaw enforcement officers lie, just like the police officers, and make things up which aren't even in the bylaw. I caught the Steve Heineman breaking the law one time in a meeting, and I said, you better read your own bylaw. We're having a meeting here, and I'm teaching you your own law. Same thing I did with the city lawyer. Read the statutes and make sure that they all apply properly, because under the broad authority of the municipality, they don't have the right to regulate private property. I've covered that. That's under Section 14, if I remember right. Now, look at an order or a warrant. Okay, and I just pulled one off the net here. Now, in this case, you see a seal up in the top corner. It might be on the left-hand side, right-hand side. Now, in this case, it has a court file number. CV for us is a civil claim. It has to have the proper court. It has to be signed by a judge. If any of those things are missing, then the order is not valid. And if they show you some garbage on a phone, well, you can't get a copy of it. So tell them I want a paper copy, and they'll tell you that we don't have to produce it. In actual fact, they do. Right. I can claim whatever I want. Doesn't mean I have the legal right to do it. And unless it's executed and authorized by court, I can't do anything. So I want a hard copy of anything. They can come back tomorrow with it if they need to.
Yes. And this is what happened in the case with the Julia's ex, as I mentioned before. They turned up with something on an iPad, and they said, there it is. And they claimed to be from the magistrate's court. They claimed that they were court bailiffs, is what they claimed. They had no identification on them, and they weren't showing their lanyard with their identification. They did have it, only showed it sort of once they were sitting in the car, but not initially. And we were saying, well, where's the hard copy? It's not signed, or there's some sort of squiggle. We can't really read it. We can't see the name of the who signed it. We want a hard copy. And they had come on a bank holiday Monday, which it's all, court judges, court bailiffs do not work on a bank holiday Monday. There were so many things wrong, but so well, we need a hard copy. Thank you very much. And they couldn't provide it, and didn't provide it, and wouldn't provide it.
Right, so if you happen to have their name or their license plate number, you could actually go after them.
Right, yeah, we probably got it on film.
Yeah, so that takes care of that. It's unlikely that you'll ever get help from any lawyer, because a lawyer is a member of the Bar Guild, as is the officers of the court, which are the cops and the lawyers and all the rest of it. Okay, so if you go to get help from a lawyer, they may or may not even know the law, because, I've talked to in my case, I contacted every municipal lawyer in Ontario. And I don't know how many hundreds there was, but I did. None of them would take the case, because you're going against another officer of the court, because the municipality hired a lawyer. In my case, they hired Jennifer Savini, who works for Templeman LLP, and she's on record as stating that she doesn't even know how to defend the case. So you'd have to educate them on the law anyway. So you might just as well do it yourself.
Absolutely.
And policy is not law. Now, if you did get railroaded, as I said earlier, you could take them to court and prove that they have operated in bad faith. Once they've operated in bad faith, and this applies to you guys in the UK as well, a bylaw passed in good faith under the Act shall not be quashed upon review in whole or in part by any court, because of unreasonableness or supposed unreasonableness of the bylaw. However, if they operate in bad faith, in other words, they do things that are less than honorable to try and push through their bylaw, then that bylaw has no force and effect. So you can challenge it under Section 272. There you go. Now, an application to quash a bylaw is under 273, and an application is actually an application to the court of any person to Superior Court, so you have to go there. The justice may quash the bylaw in whole or in part for the illegality. So if it's illegal what they're doing, that's what I said. If it's illegal, you can quash it. The bylaw includes, and remember, includes is restricted to an order or resolution. And because these corporations have taken on the role of a natural person, you can go after the people in charge. So that's why you always want to find the compliance officer or the chief administrative officer in the case of an Ontario law, because it's their job to make sure the corporation operates within the confines of the law. So now you've got a name of somebody you can go after. Now, many people go through this notice of liability process, which is a separate presentation. If there's interest, we can do that, in the future. It wouldn't take too long to wipe that up. And then you guys will understand what that is. And it applies in the UK because, especially in the UK and or the United States, because you guys have a slightly different process in that you try to do your paperwork ahead of time. It's called a pre-action protocol. And so what I'm trying to do is get people to have the evidence and the ammunition for their pre-action protocol, and then when the other side doesn't dispute it, because they can't, then there's no conflict, and if there's no conflict, there's no reason to even go to court.
Right.
We want to eliminate as many of the issues as we can up front. Maybe there's 10 issues. We can resolve 8 of the 10. We only need to go to court for the 2. Right? Now, this is the standard protocol for the civil procedures, which I tried to educate the city lawyer on, and she conveniently ignored it. There's 2 different protocols, but you put in a claim, Okay, and a statement of claim is what we call it, or in the case of the municipality, in the council issue, they would file a complaint, which is the same as a claim. You should be allowed to file some sort of a defense. And then in certain court cases, and they always try to recommend you do mediation, which is the meeting between the two parties to resolve some of the issues if possible. Then you set the matter down for trial. Then you go to a pre-trial hearing usually, and then it goes to actual court. That's the general protocol. Now, in our case, they ignored all that. The Toronto court ignored that. So Sean Dunphy, who was the presiding judge, rendered a verdict in less than 5 minutes when I had 273 pages of evidence.
My goodness.
And the other side didn't even file a defense properly. Yet I was found guilty. So there goes your corrupt court system. And this is what aggravates me. This is what drives me to help you guys. Because if enough of us stick together, maybe we can end this tyranny. The same thing with this council tax. I mean, I've seen what happened to Julie, the little bit that you videotaped. I know of other people. And I don't like to see people getting railroaded and basically run through the meat grinder, which is why I produce these videos with you.
Absolutely. And we're very grateful.
I thank you for having such a platform, because people have to be notified of this because they don't know. People get some piece of paper and they freak out. What do I do with it?
Yes.
Right? They don't know what to do with it.
No, and what you're doing is you're giving reassurance that they don't have to panic.
Right.
Because most people on average don't normally have to jostle with the law or have legal documents, and they may be genuinely struggling to do something and it's come out of the blue from some nefarious activity. They may have been had a reason not to pay the council tax because they didn't believe that actually what the council were doing, aiding and abetting terrorism, for example, and putting money towards things they don't want, like might be 5G, or sending it to the government to fight in foreign countries where they've not had a mandate to do that. So they might have legitimate reasons to hold back paying and have a number of questions that they want answered and proved first. But when they get this claim or the documents from fake courts, they start to panic. And so having people like yourself on the show, of course, is reassuring to them that there is a remedy or a route towards remedy or a process that they can follow. So, yeah, we're all grateful. Right, next slide.
Next slide, please. Okay, is there a way to appeal the property standards order? Yes. You can go through the appeals process within the municipality, which means you actually have to pay the criminals so you can have your hearing in front of their own criminals. That doesn't sound like a very good system, but that's what they do.
Yes.
Because this creates a conflict of interest. The appeals committee has one task, and that is to uphold the corporate policy. So if you can convince them that the municipality has no authority based on the letter that you sent previously, you may or may not win. Well, the thing is, if you sent them the law to show them where they have no authority, you've already won because you've proven it. And then whatever they do, you can basically say, well, I've already given you the law. So if you want to proceed further, now you are knowingly engaging in an act of fraud or misrepresentation, malfeasance, whatever.
Yes.
Now, many times they don't care. Now, this is one of the issues that happens in Ontario. And we're kind of unlucky in that fashion, that if the municipality does something illegal or stupid, then they will eventually, if they get a judgment, they will put a lien against your property, which will prevent you from remortgaging your property or being able to sell your property. Now, I'm working on a remedy, and I'm not going to discuss what that is publicly, but when I get it solved, I will have the remedy, and if it'll work out, I will let the public know how to solve that problem. So I am working on it in the background, but it's not an easy task because I'm trying to crack the egg. If somebody wants to share some information, send it to Richard or myself, and he'll make sure I get it. And then maybe we can build a remedy, because you guys, what they do is they go to attack the property of your vehicle. So you guys are a little bit more protected. Just make sure they can't find the vehicle, and basically they're home free. Now, in the case of the UK, they'll generally come to your house 3 times, at least 3 times. And the first time they have to give you 14 days notice. So you already know they're coming. That's the protocol that you guys have. In our case, in this court system, if they get a judgment, they simply put a lien against your property, and then you can't remortgage your property until you pay off the lien. So they got you over a barrel. And you can't sell your property when there's a lien against it either. So this is why we need a remedy in that situation. However, I'm just telling you I'm not sugarcoating or hiding anything. I'm telling you exactly what the law says and exactly how they operate. I've lived this for 40 years with harassment, so I know how it works. Now, confirmation of an order. If an order is not appealed in the time frame referred to subsection 1, it'll be deemed conformed. So if you don't say anything against what they do, then you're screwed. Now it says here, if you pay your stupid extortion fee, which creates a conflict of interest, the committee shall hear your appeal. Powers of the committee. On appeal, the committee has the same powers and functions of the officer who made the order, and the committee may do any of the following things. If it's in the committee's opinion, doing so would maintain the general intent and purpose of the bylaw. So that tells you that if you go to the appeal through the local council here, they're going to try and maintain the general interest and purpose of the bylaw and the official plan or policy statement. So they're not going to follow the law.
Right.
They're going to try and uphold the law, the bylaw, so they can extract funds from you for this breach of the bylaw, which they have no authority to produce in the first damn place. Now it says they can confirm, which they're going to, modify or rescind the order to demolish or repair. So they can only modify or rescind an order to demolish or repair, which means they're going to confirm everything else. Because there's a comma there. Read the sentence for what it is. So there's no way that if you appeal to the local committee, it's very unlikely, I can't say there's no way, but it's very unlikely that you're going to get a fair hearing at your initial review when you go through paying the council for having a private meeting. And it is private, and now what they do is they publicize it on Zoom, which is yet another conflict, because you're already pronounced guilty, and yet they're not a court of law. The municipality does the same thing. If there's a tenant dispute, they'll step in and they'll try and find the person under some infraction, and they post it publicly. So that's slander. Municipality for the City of Belleville was good at that. And then they turn on and post it publicly, and then you haven't even had a trial yet, and you've already been convicted.
I'm gonna have to get you to speed you up a little bit, because we're an hour into the presentation, unfortunately.
All righty, next slide. Now you can appeal to the court, and I've given you the process for that. And the judge's power on appeal has the same power and functions as the committee. So again, if you try to appeal your first appeal, if they appeal the second appeal, they're going to turn around and go against you anyway, more than likely. Next slide. Now, if I lose the committee meeting, now what? Now you're forced to go through the process and appeal it to the higher court, and I've just shown you why that won't work. So you'd have to show where they operated in bad faith. Next slide. Municipal liability. Immunity, 448. No proceeding and damages shall be commenced against a member of council or an officer, employee or agent of the municipality, or person acting under the instruction of the officer or agent if they're done in good faith. Well, when they operate outside the law, which is their duty to know, then they're not operating in good faith, and there's your remedy. But they're going to try and pull this 448 against you. You just know that they've operated in bad faith. You can say that doesn't apply here. Next. Every person who operates before a court in the province of Ontario has the right to record his or her own court hearing, which is given under Section 136, Sub 2B of the Ontario Courts of Justice Act. They'll tell you don't have the right to record your court case. That's BS. There's the proof. Okay, but you can only record your own court case.
And is that I mean, we hear that in the UK a lot, where people say you can't, no recording, you can't, video or audio record it. And they'll take all your phones or recording devices off, although people come in with different devices in order to do that, so that they can, make it a public record. Right,
and you can in the UK record your own court hearing as well. I've already checked it out. I was told the same thing, and I gave the guy the law because they were going to come after my client and said, you can't do this, so we're going to address this in the court. And I said, here's the law, says they can do it, so now what are you going to do? And the lawyer walked away from it. In fact, the lawyer gave up the whole case. If the court operates outside the law, you must prove the violation within the law, and then you have the case declared void. Once that happens, the court loses jurisdiction permanently because they don't follow the law, and the persons involved are not protected from legal prosecution, so you can go after them. Same thing happens in the UK. Okay, now that's where we get into appeals versus judicial review, and I'll save that for another day. Next slide. No person shall be convicted of an offense in respect to an act or omission or obedience to the laws for the time being made, and enforce the persons in de facto possession of the sovereign power and over the place or the act or where the omission occurs. That means you, the individual, can't be convicted for an offense with respect to an act or omission because you're following the act. Okay? You're following the statute, so you can't be convicted. You have to know that. Next slide. When respecting yourself, okay, you're not practicing law. When you're representing yourself, you can do as many court cases as you have to. The Law Society can't say anything about it. Now, if you try to bring in a friend to help you, the Law Society can ask how many cases you've done, and they can give you a hassle. And in fact, the judge illegally could refuse your defense. This is why I tell people to learn and know their own court case. And the same thing in the UK. I can't or nobody can represent you. You have to represent yourself or hire a lawyer.
Right, which is daunting for people.
Now, what you can do if you need to is you can bring somebody in as a Mackenzie friend. Now, they can't address the court, but they can help hand you paperwork, point out things, take notes, this kind of thing.
Yeah.
Now, and you don't need a license to practice law when you're doing your own court case. And for those that need to, can pause this and keep it. I'm not going to go through it because that would take some time. Next slide. And same on that one. Somebody can record that or capture that. Now, if the municipality tries to add a cost to clean up to your taxes, they're not allowed to do this. And if they dispose of anything, it's theft under the Criminal Code of Canada. And depending on what they took, they may have salvage value, which would be applied against what they took. But you can also dig up court cases and prove that they had no right to take that. And I can give people those court cases if they need them. Fourth, the municipality is not allowed to charge taxes in the first place, and refer to Section 17 of the Municipal Act. So, in fact, you guys are all being hoodwinked, same as you guys with your council tax within the United Kingdom. Next slide. There it is. Sections 9, 10, and 11 regulate everything the municipality does. And Section 9 is a natural person. We did that. 10 and 11 deal with public assets. But it also says right here, under Section 17.1, sub A, they're not allowed to impose taxes. So everybody's property that's been paying property tax in the province of Ontario has been doing it illegally. And a lot of times they borrow or invest money to casinos and other corporations, and they're not allowed to enter into agreements for minimizing costs, which is what they do when they hire a lawyer. So that, again, is illegal. Look into that act. Next slide. Now, final thoughts. If the municipality, including the police or municipality, tries to get you to do anything, ask them to show you the law which obligates you to do whatever it is they're asking you to do. And remember, you have time to read that and understand it. Don't just take the paper and see, okay. Remember that everything you do is a contract. No one can force you into a contract. Next slide.
And okay. just on that, that's very important. That point. I know we're rushing through the end there, but I think that's very important. That you should say, where is the obligation? Show me exactly, and then you have the time to read it. I think that is that's a very wise piece of advice that you've given there.
Yes, and many times the police won't have it. They won't. Well, it's in the bylaw. Well, then show me the bylaw, or show me the act. Bylaw exactly. Is only a bylaw, right?
Yeah, and half the time the police don't even know themselves.
That's right, exactly. Well, if the officer showed me the law, so that's good enough. No, it isn't, because now the police officer is engaging himself or herself in a civil matter, which they have no authority to do.
Exactly, yeah.
But they will try to intimidate the daylights out of you. Next slide. Okay. If anyone tries to interact with you, say as little as possible, because anything you say will be used. And be sure you record everything. Get a hold of a body camera or a microphone with a clip that can go to a personal recorder. Don't put the recorder in your pocket, because when you move, the microphone will pick that up. Get the names and identification of everyone. If they won't give it to you, photograph their name off their shirt. They're in public. They have no expectation of privacy. And be sure to follow up every interaction with a written letter of understanding, allowing the other side a chance to dispute the points that you present within the letter, and give them a time frame, usually 10 days or so. And if they don't, then they have agreed with the statement made within the letter, which you then will use as evidence in court. That, my friends, is key. Okay? Because then you can say, this is what transpired, and I presented it, they didn't dispute it, therefore we're in agreement. What we're trying to do is get them in agreement so there is no conflict. If there's no conflict, no reason to go to court.
Right, exactly. Yeah. And many people do that. They'll send in and say, look, this is the state of affairs. You've got a chance within the next 7 to 10 days, whatever the time limit is, to rebut it. Yep. And I mean, I've done that myself. with the council tax, and they haven't rebutted it. And so in the end, you put them on a final notice or a notice of default and say, well, you tacitly agreed by your silence that this must be fact. This is now true. Thank you very much. And
right.
and then if they
if they proceed, then they're breaking the law. If you want, Richard, we can do a presentation on notice of liability, how that all works, so people will understand what we're talking about.
Mm.
If that's of interest, we can do that. But anyway, next slide. Okay, I'll provide legal documentation, including all the laws applicable to for the property rights from the municipality for a fee of $150. It's a fairly lengthy book that I'll have to print out. Okay, and I'll give you his phone support because I don't want to see everybody get screwed over. I can't keep doing legal work for people for free, obviously. I need an income source too, right? The process of learning this took me actually over 29 years and countless hours in aggravation of research, spending time in court, filing paperwork, learning what works and what doesn't. And that's my life, basically, and it's worth something.
Yeah.
Right?
Absolutely.
People don't work for free all the time. So anyway, that's, if you want to contact me, I can be reached at that email address. If somebody wants to make a contribution, it's the same address. But I'm not pushing that. And please also indicate a time of a call for your 30-minute consultation, which usually is about 45 minutes. But anyway, if somebody needs help, I'm willing to do that. And there we are. Next slide. I think we're done anyway. Yeah.
I think we're done. And we'll share this on your channel as well.
Yeah, I'll do that once it's posted. I download it and re-upload it.
Yeah, absolutely. Brilliant. And so, so a lot of that is, it's obviously aimed at Ontario and Canada law, but as you said, there are absolute parallels with the UK. You might have to go and find the UK legislation bits, but you've given us all the pointers to go and find it.
Right. And that's why generally I bring up the law, or I get Richard to look it up, but in this case, it would have taken too long.
Yes.
We're already over the 1 hour time frame, so...
Yeah, and I apologise for pushing you through that. It's just, I know people won't watch these presentations if they seem to be over an hour or so. So we want people to watch them. So the more they get to see these sort of things, even if they don't fully understand it, the more they get to see them and look at some of the other presentations we've done, the more it gets into your system that you understand that these laws are written by other people. And, don't be duped by them, because there's usually a remedy within them, even though you might have to search a little bit for it.
Exactly. What I tell people to do is print out the law in case they change it. And then you can always go back. I have books and books and binders of this crap. And I keep it in a binder because if I have to photocopy the page out of it, it's fairly easy to do. If I get it in a Sherlock's bound book, well, now I got to tear it all apart. So I just print it out. And keep in mind, when they find a loophole in the law, then they will change it. But if you can go back and say, yes, but this is applicable at that time, because often the lawyers will bring in the revised law, but by the time you get to court, and they'll say, well, it doesn't say that, and then you're like, oh, it's true. But if you have your own proof and say, here it is in an exhibit, in an affidavit, then they can't dispute it.
Right. Brilliant. Stan, thank you so much for that presentation. We'll do some more, and we'll certainly consider doing the Ask Stan live event, and I'll publicise that in due course.
Sounds good.
And brilliant, wonderful. Thank you so much, Dan. Appreciate that.
You're welcome.
I'll be back with more interviews and more wonderful guests, etc. In the meantime, from Stan and I, thank you so much for watching. Hope that was of some use, and I'll put the links to Stan's contact details, etc. in the description as well. So there we are. That's it from Stan and I. Thank you so much for watching. Till next time. Bye for now.